Very good evening, students. Good evening, everyone. Any volunteer, please confirm about the voice and the video. Very good evening, Sammy Gill. Please confirm about the voice and the video, and I'll start the session. Chaliye. Thank you, Srishti, for confirming that. Very good evening, Kanchan. On that note, let's begin with this class. So first of all, I welcome each one of you to my class on the MCQ test of Contract, Specific Relief Act, and Sale of Goods Act. Let's start with my brief introduction. In case if you don't know my name, it's Sandeep Khatri. These are my areas of specialization. As you can see on the screen, the constitutional law, criminal law, commercial law, family law, jurisprudence, and law of torts. Students, I have also shared the link of my profile of Unacademy, which you can follow to get all the updates about my special classes and my plus courses. I have also shared the link of my Telegram channel where you can connect with me in relation to your judicial preparation. At last, I have mentioned my code, that is Khatri10, which you can use to get free access of all the special classes available on Unacademy app. So this was about me. Now I request everyone, please be attentive, and this is going to be an interactive session. So the moment you feel you want to ask anything, any question, so feel free to write your questions in the comments. So here comes the MCQs. I hope you all are ready. So please close your Bare Act notes, everything put aside. And here comes the first question on your screen. One humble request before starting the test, that make sure you write the question number before the answer. So whatever your answer is, first question number 1 and then the options A, B, C or D, whatever you feel like. So here comes the first question. From the Indian Contract Act, we are starting. So the person making the proposal is called the dash and the person accepting the proposal is called the dash. Choose the most appropriate option. Very good evening, Shivangi, Sonia, and everyone, those of you who have just joined. Top 3 students to answer correctly. First one, Shivangi. Second one, Kanchan. Followed by Sammy. Yes, everyone's answer is correct. That is C, promisor and promisee. So this is basically, we are talking about section 2C. Can anyone tell me where the term promise has been defined? Under which section the term promise has been defined? Please do write in the comments. Sammy Gill, correct answer, that is section 2B. Section 2B defines the term acceptance as well as promise. Okay. Kanchan, the correct answer is section 2B. Okay. Yes, correct answer, Shivangi. Next question. Over a cup of coffee in a restaurant, X invites Y to dinner at his house on a Sunday. Y hires a taxi and reaches X house at the appointed time, but X fails to perform his promise. Can Y recover any damages from X? Choose the most appropriate option. Top 3 students to answer correctly. First one, Shivangi, followed by Monica and Srishti. Everyone's answer is correct. That is B. The answer is no. Y cannot recover any damages from the X. Now the question is, why not? Because there was no contract. Now, why there was no contract? The reason was very simple, because there was no intention to create a legal relationship. Okay, this is one of the examples of your social agreements. Okay, and social agreements will not fall into your contracts. Next one. An acceptance on telephone should be heard by the offerer, audible to the offerer, understood by the offerer, all of the above. Top three students to answer correctly: Shivangi, followed by Antpal and Sammy Gill. Yes, D is the correct answer. Kanchan, please do correct your answer. For an acceptance, that should be heard. See, when it comes to heard and audible, they both are basically the same thing. So heard, audible, understood by the offerer. Okay, that whatever has been spoken. Now I have one interesting question in association with this concept, and that is, let me give you an application based situation. So suppose there is a person uh, from Delhi, he's calling the another person from Mumbai, and the person who is in Delhi is giving the proposal, and the person who is in Mumbai is giving the acceptance. So the acceptance has been said in Mumbai only, but the acceptance has been heard in Delhi, right? The person who has given the proposal. Now my question is, which is the place where contract has taken place? It is Delhi or it is Mumbai? Answer in the comments. Which is the place where contract has been made? Delhi or Mumbai? So basically I'm asking you, the place where acceptance has been spoken, that is the place of the contract, or the place where the acceptance has been heard, that is going to be the place of contract. Okay, I have got the answer, and top three students to answer correctly: Kanchan, followed by Antpal and Sammy. Correct. Everyone's answer is correct. That is Delhi, because the acceptance has been heard in Delhi, and because of that acceptance has been heard, communicated. That is why we can say the contract has been made in Delhi. Next one. Which one of the following element is not necessary for the contract? Chaliye. Thank you for the kind comments, Chandar Huda. You're welcome. Okay, this question was, I don't think question number 4 was difficult. Some students are writing B, some students are writing D. Okay, let's read the question again. Which one of the following element is not necessary? So I think some of you have committed a mistake here only. You have just ignored this term not. Okay. So element is not necessary for a contract. Competent parties. As per to section 10, do we need competent parties? Answer is yes. Free consent. Answer is yes. Okay. Lawful consent. Okay. There is a spelling mistake. Now I can understand why some of the students are writing D. So this is basically consideration. Okay, this is basically consideration. There's a spelling mistake in this. Okay, So now coming to, obviously lawful consideration is also required. So the thing is reasonable terms and condition. That has nothing to do with a valid contract, because whatever the terms, whatever the conditions is, that is something which is going to be decided by the parties only. The parties are going to decide what are going to be the terms and condition. Okay. So B is the correct answer, and there is a spelling mistake. This is lawful consideration. Okay. Moving to the next one. In a standardized contract, choose the most appropriate option. If you know the meaning of standardized contract, this is going to be very easy one for you. Choose the most appropriate option. Top three students to answer correctly: Shivangi, followed by Simran and Sapna. And I guess everyone's answer is A, and that is completely correct. Okay. So this is basically one individual who is entering into a standardized contract. That person has no choice but to accept and sign on the dotted line. Okay. So basically, you cannot negotiate. There can be two examples you can take. So suppose if you are buying an insurance, okay, for your car. Now, whatever company you have chosen, that company, so whosoever is going to purchase the same insurance plan from that particular company, the terms and conditions are going to be the same. Okay. Or suppose if you are installing any app in your mobile phone, so the conditions are going to be the same. Okay. Next. This one is interesting. Let's see who so. Yes, online shopping can be also a good example for that one. So if you are suppose buying anything from the Flipkart or Amazon, so that will fall under standardized contract. Okay, now coming to this one, let's see who can answer this correctly. There are two statements that has been given. You need to tell me which statements are correct. First only, second only, both, neither. Okay, let me tell you, if you have read Mohiri Bibi case, the landmark judgment that relates with the minor, if you have read that judgment in detail, I don't think you should face any difficulty while answering this question. Okay, now let me see whosoever has answered this correctly. Top three students to answer correctly. First one, Anumitro, followed by Kanika and Shivagori. Yes, only three students has answered this correctly. Okay, now let me give you the reasons. Okay, if you have answered, most of you have answered C, which means you completely agree that there is no estoppel against the minor, right? And this is completely correct. You cannot enforce estoppel against the minor, right? This is the correct statement. Now coming to this one, okay. If an infant obtains property or goods by misrepresenting his age, he can be compelled to restore it even though the infant has sold. Now just assume, if that minor, okay, has already sold the goods or or converted them. Now you tell me, how can you recover your property? Is there any provision available? The answer is no. And even if you have read Mohiri Bibi, in that particular judgment as well, I think the correct amount was somewhere around 10,000. So the minor was not liable to repay that 10,000 rupees. Okay. But yes, if the infant has not sold the goods, then you may recover it from the minor. Then you may. Okay. But if the infant has already sold, then you see, the whole idea is you cannot put liability on the heads of the minor. That is the idea. But if he still have the goods, if he has not converted them, so then you can easily, restore them. I hope it's clear now. Okay. Next one. And still, if you have any doubts, feel free to write your question in the comments. Okay, Simran has come up with a new concept that if he misrepresented it, then we can cover from the guardian. No, no. We are dealing with law of contracts, not law of torts here. In case of law of torts, you can recover it from the guardian in case of vicarious liability, but not in the case of law of contracts. Okay, next one. This one is again interesting one. A guru, spiritual advisor, induced the chela, his devotee, to gift him a whole of his property to secure benefit of his soul in the next world. The gift shall be. It's like कि सब मोह माया है basically. Okay, and whatever you have, the money or the basically if you want to have the moksha, then just give it all to me. So in that case, now you choose that particular gift shall be. Choose the most appropriate option. First you answer this, then I'll ask some more question associated with this one. Okay, let's see who has answered this correctly. Everyone, please do participate and just answer as per to whatever your mind says. If you are saying the answer is C, D, A, B, whatsoever, okay, just answer from your mind. Okay, top 3 students to answer correctly. First one, Mohit, followed by Shiv Gauri, followed by Anomitro. B is the correct answer. Now, how B is the correct answer? Let me tell you that as well. My question number first, whether gift is a contract or not, please do answer. Yes. Whether gift constitutes a contract or not, answer in the comments, yes or no. Anomitro, yes. Kanchan, yes. Shiv Gauri, yes. Okay, everyone is writing yes now. So I'm assuming everyone knows. Yes under section 25 if Indian Contract Act. बहुत बढ़िया Simran. Okay, Kanika, no. Kanika, why gift is not a contract? So let's take an example. See, gift is also a kind of contract. First thing, Kanika. Now the second thing, sir, why it is a contract? Just because there is no consideration. So section 25 has one more exception, that is in terms of gift. Gift is also the exception of section number 25. Okay, so basically, the idea behind this is कि suppose there is Mr. A and he gifted something to B. Now, after 4 days, they had a fight. Now, can B recover his gift? Can A recover his gift from B? And the answer is no. The answer is no. Done. So the thing is, just because there is no consideration, gift is also a form of your contract. Now coming to this particular situation. Now this guru and this chela, they have the fictitious relationship. Okay. And because of that, this is complete case of undue influence. There is no coercion. Okay. There is no fraud. There is no misrepresentation. There is no mistake involved, but yes, this is a complete case of undue influence. And because of that, we are going to treat that as a voidable contract. I hope it's clear. Okay? Chaliye. Next one. The terms of gift is uncertain. How the terms of gift is uncertain? No. The terms of the gifts are not uncertain. Okay. Once someone has made the gift, that's it. Okay, answering to your question, Simran, I mean getting moksha is also uncertain. So should not it be void? No. See, the thing is, we have to see the relationship between the parties. When it comes to a guru and a student, one can be easily influenced by the other one. right? When it comes to relationship of a advocate and a client, doctor and a patient, teacher and a student, educator and a student, guru and his chela. Okay, so we have to see the relationship. Next one. Okay, a contract caused by one of the parties to it being under a mistake as a matter of fact is. Top three students to answer this correctly: Anumitro, Monica, and Mohit. A is the correct answer. Okay. Why you are writing C? Voidable at the option of either party. No students. Please do correct yourself. Antpal, Shivgori, please do correct yourself. C is not the correct answer. Why? Because a contract caused by one of the parties, only one is under the mistake. If only one party is under the mistake, and that mistake is also as a matter of fact, that will not impact the contract and it will result into valid one. Okay, so valid is the correct answer. Yes, Kanchan, you may refer section 22 as well here. Next. Unlawful detaining or threatening to detain any property with the intention of causing any person to enter into an agreement would amount to which of the following? Okay, I have very interesting question in relation to this concept. So first you answer this one, and after that I'll raise that question. Okay, I guess easy one. Starting from Kanchan, everyone is writing C. Anometro and Monica. Yes, everyone's answer is C, which is the correct one. So it's a clear case of coercion. Now I have one interesting question for each one of you, and that is when you read that section of coercion, okay, if you go by the wordings of the section 15, you know there is the term IPC has been used. Okay, now my question is, what if someone is committing an offense under any special law? So will that amount to coercion? Yes or no? Answer in the comments. Will that amount to coercion? Yes or no? If that is not from IPC but from any special criminal law. Kanika, if you are saying yes, please do give me the reasoning. Mohit, please give me the reasoning. Shrishti, if yes, give me the reasoning. Ladley, give me the reasoning. Reasoning. I'm getting the answers, yes, sir. But please do tell me the reasoning. Why yes? Why yes? Prohibited by law. Okay, the first reasoning I have got from Mohit, that is prohibited by law. Then for that, I do have a counter question. The forbidden by IPC, the term that has been used is forbidden by IPC. Section 40 IPC. No, Kanchan, section 40 of IPC will not save you here. From here. No. Section 40 will not save you here. Now let me tell you the answer. See, the answer here is you see, the first thing first. As an advocate, as a judge, what we are going to follow? We are going to follow the law. And if there is a codified law, which is section 15 here, which specifically says IPC, then we cannot go and enter into any of the special laws. Then, sir, what's the solution? The solution is this needs to be updated. There has been recommendations that has been made by Law Commission of India that the amendment should be here, that the term IPC should not be used, any criminal law should be used. But as of now, no amendment has been made. So you just, all I want is that you should be aware about this about this recommendation. That's it. And as far as section 15 till this date is concerned, we are only going to refer IPC because of the codification. Done? IPC section 40 has nothing to do with this. Okay. Next. B says to A, if you do not deny it, I shall assume that is sound. Okay, that is sound. So basically, they are talking about that if you are not going to deny this fact, I'm going to assume that suppose the horse I am buying is completely sound mind. So A says nothing. Now, in this particular situation, the A's silence is equivalent to, choose the most appropriate one. Top three students to answer correctly. First one, Kanika, followed by Simran and Kanchan. Yes, D is the correct answer. That silence will be equivalent to speech. That silence itself will not become fraud. Okay, that was the catch. You have to read the question again. B says to A, if you do not deny it, okay, I shall assume that is sound. A says nothing. Here, A's silence is equivalent to speech. Okay, there are no facts given in the question that the fraud is taking place. So that is why D is the more appropriate answer here. Moving to the next one. When an acceptance may be revoked. I think it's an easy one. If you have gone through with the section, it's kind of a direct question only. Okay, starting from Anumitro, followed by Ladley and Shivangi, top three students to answer correctly, and B is the correct answer. Okay, okay. Now answer this. Obviously, if you have answered this B, so I can assume that you are completely clear with the concept of section number 4, right? Because if you don't know about section number 4, then you just cannot answer this question. Now the thing is, students, when it comes to the application of section number 4, my question is, when it comes to the application of section number 4 applies on inter absentees, inter presentees, both or none of the above. Now let me tell you the meaning as well. What is inter absentees? What is your inter presentees? Inter absentees means when you are communicating with someone and the person is not present in front of you. For example, when you are when you are writing letters to one another. Okay, so that is the case of inter absentees. Inter presentees, when the parties are physically present in front of each other and they can easily communicate with each other. So now my question is, when it comes to section 4, it applies to inter absentees, inter presentees, both or none of the above. Answer in the comments. Kanika, both. Kanchan, post. Ladley, both. Anometro. Okay. Kanchan, see, do understand the meaning of inter absentees. Inter absentees means the person cannot reply to your question immediately. Okay, done. Okay, top three students to answer correctly. First one, Anumetro, followed by Kanchan. Okay, Kanchan, you have written both, so I'm not including you. Monica, okay. After that, once your meaning is clear, then you're writing okay. Done. Shivagori, correct answer. So the correct answer here is inter absentees. Section 4 applies to only inter absentees. Okay. Next one. A, being in debt to B, the money lender of his village, contracts a fresh loan on terms which appears to be unconscionable. This will be termed as. It's okay, Kanchan, you don't need to be sorry. Top 3 students to answer correctly: Kanchan, Nawab, and Simran. Yes, C is the correct answer. Raja, please do correct yourself. A is not the correct answer. This is a case of undue influence. Okay. As far as the facts given in the question concerned. A wagering contract is dash, whereas a contingent contract is. I think the easy one, you should not take more than 2 seconds to answer these kind of questions. Okay, 13. Starting from Anomitro, followed by Kanchan and Monica, everyone is answering A, and that is the correct answer. Yes, section 30 and 31. Perfect. Now, my question is, students, when it comes to wagering, by the way, even in the question itself, the term that should be used is wagering agreement. Okay, there is nothing like wagering contract. The correct term should be a wagering agreement. Okay. Now the thing is, when it comes to wagering agreement, there is happening or non-happening of an event, right? What? Okay, not a good example. Chalo, let's go there. Matlab, nahi, that is. Chalo, let's just ignore that question. Moving to the next one. Moving to the next. I just don't want to discuss cricket, so that's why I'm moving to the next one and focus on the test only. Okay, next one. Question number 14th. Yes, please. A borrows rupees 100 from B and gives him a bond for rupees 200, payable by 5 yearly installments of rupees 40, with a stipulation that in default of payment of any installment, the the whole shall become due. Choose the most appropriate option. I know generally students don't read section 73, 74, and 75 in detail. I know about this. And that's why I have included this question. And the reason is very simple, because section 73, 74, and 75 is more important when it comes to the mains examination. Okay? But still you can always expect a question like this. Starting from Anomitro, Ladley, and Monica, everyone's answer is correct. That is D. Okay. Kanika, please do correct yourself. Millie Jan, please do correct yourself. This is basically an illustration. Okay. This is one of the illustration of section 74. And the answer is, this is a stipulation by way of penalty. Okay. You can do that. Fine. Next one. Yes, Millijan, completely correct. This is basically the illustration from the explanation of section 74. Completely correct. A gives B a bond for the repayment of rupees 1000 with interest at 12% at the end of 6 months, with a stipulation that in case of default, interest shall be payable at the rate of 75% from the date of default. I got three answers to this question. One is A, one is B, another one is C. So, whom should I believe? Anumitro, Shivagori, and Kanika. Correct answer. Okay. This question is basically from the general rule of section 74. Okay. Where this is going to be a stipulation. But again, B is only entitled to recover from A such compensation as the court consider reasonable. So A is the correct one. This is basically from the general rule. Okay. So A is the correct one. B shall be entitled? No, B shall not be entitled because reasonableness will be seen. Yes, again, illustration from section 74. Which of the following is an exception of section 74? Top three students to answer correctly: Anumitro, followed by Nawab and Ledley. Everyone's answer is correct. That is C. So it's central government as well and the state government as well. This includes bail bond as well. Please confirm yes or no. The exception of section 74 includes bail bond. Yes or no? I'm happy that Anumitro is answering in seconds. Good. Yes, the answer is correct. Bail bond is an exception. Next one. I hope the question is not that difficult. I have got just one answer till now. Kanika, language. What about the language, Kanika? This is again an illustration only from your Bayer Act. I have just made some, the options A, B, C, D has been made by me. Rest is completely from your Bayer Act. Yes, Simran, this is an illustration of section number 62. And top 3 students to answer correctly here is Anomitro, followed by Simran and Shiv Gauri. So B is the correct answer. Okay. So basically it extinguishes the old. The moment you come up with a new contract, that extinguishes the old. Okay. Uh, Kanika, just refer the illustration of section 62 after this class. Okay. Done. Next. A and B contract to marry each other. Before the time fixed for the marriage, A goes mad. This is. This is. Read the question carefully. This is not that easy. I have got all the answers except A. No one is saying it's a valid contract. See, this kind of questions na actually challenge your conceptual knowledge. Let me tell you this. Anomitro, you have changed your answer. And what about others? The one and only who have answered this correctly is Kanchan. D is the correct answer. D is the correct answer. Now the question is, sir, how? How this is a situation like contract becomes void? Read the first line. A and B contract to marry each other. A and B contract to marry each other, which means the contract has already been made. And once the contract has been already made, it cannot be a case of void agreement or voidable contract. But after that contract, before the time fixed for the marriage, A goes mad. Now you just cannot perform your promise. So this is something which will fall under contract becomes void. So at the same time, it was not that difficult as well. Yes, 56. Ab tak 56. I hope everyone is clear with this. Okay, I have one more question associated with this. If A and B are coming into a contract to marry each other, will this not fall under section 26? Will this not fall under section 26? Because I know whosoever has answered, B, void agreement, that student has actually applied section 26 here. So yes, please do tell me, if A and B are having a contract to marry each other, will that be restricted by section 26 of Indian Contract Act 1872? Wonderful, Kanchan. No restriction here. Shiv Gauri, yes. Shiv Gauri, if your answer is yes, then how can this will fall under contract becomes void? Then the answer should be void agreement. The answer to my second question is section 26 will not, come into the picture here. Reason why? Because section 26 is basically talking about restriction. You cannot restrict someone that you cannot marry this particular person. Okay? So there is no restriction. They are entering into a contract to marry each other. And there is nothing wrong in that. Clear? Next one. X, Y, and Z jointly promise to pay D 3,000 rupees. D may compel Dash to pay whole amount. Choose the most appropriate option. Okay, Shiv Gauri. Okay. Then it's my mistake. It's okay, Shiv Gauri. Just move on to the next one. It's okay. It's completely fine. 19. Yes. Top three students to answer correctly. Uh, First one to answer correctly of question number 19, Anumitro, followed by Ladley and Nawab. And I guess everyone's answer is correct. That is D. Millie and Shivgori, please do correct your answer. C cannot be the correct answer. Why not? Simran, C is not the correct answer. Why not? Because see, when you see all jointly only, see X, Y, and Z jointly promise to pay D. So D can compel either any one of them or all three. So that is why the all jointly only is the incorrect answer. D may ask 3000 to them jointly as well and to severally as well. Okay, this is again one of the illustration, and if I'm not wrong, this is the illustration of section 43. Okay, so whosoever has answered this incorrectly, please do write section 43 in your notes. Okay, so the answer is both A or B. Okay, ji. So now coming to the questions for a specific relief act. Statutory recognition of principles of equity in the specific relief act is regarding top three students to answer correctly. This time, first one to answer Nawab, followed by Ladley and Kanchan. Everyone's answer is correct. D is the correct answer. ठीक है जी? It's okay, Anumitro. You may leave. You may leave. ठीक है? Next one. The basis of specific relief is the foundation of the concept of specific relief is on law of equity only, common law, Roman law, all of the above. Nawab, first one to answer correctly, followed by Kanchan and Ladley. A is the correct answer. Students, it is all about law of equity. Equity means fairness. It is the fairness that demands specific relief of a particular contract. Okay, so the correct answer is A, law of equity. Injunctions are such as are to continue until a specific time or until the further order of the court, and they may be granted at any stage of the suit and are regulated by CPC 1908. What kind of injunctions we are talking about here? Perpetual, temporary, both, none of the above. I think the one of the easiest question you can expect in your exams. Starting from Ladley, Kanika, and Nawab. Everyone's answer is correct. That is D. Sorry, B. B is the correct answer. Is there any time limit if any person is dispossessed without his consent of from immovable property, otherwise than in due course of law for filing suit to recover possession thereof? And yes, we are talking about section 6 here. So is there any time limit given under section 6? So can you say, and section 6 has also mentioned The period of limitation. Nawab, Kaneka, Ladley, correct answer. Yes. 6 months under section 6. Easy to remember as well. Right? 6 months under section 6. So A is the correct answer. Section 12 of SRA deals with Kanika, Kanchan, and Ladley. Top 3 students to answer correctly. That is specific performance of part of contract. In relation to ownership of property, possession is. So basically, if there is a concept called ownership of property, and on the another side there is a possession. So what is the relationship between these two? Obviously, they two are the distinct concepts, but what is the relationship between ownership and possession? First one to answer correctly, Nawab, followed by Kanchan and Simran. Yes, everyone's answer is correct. That is it's a prima facie proof. Section 5 to Section 8 of SRA deals with recovery of. Recovery of. This question is more of a word play rather than conceptual. And yes, you have committed the mistake. It was just a simple word play. Simple word play. Kanika. Okay, only Kanika has answered this correctly. Yes. Student section 5 and 6 deals with immovable property. 7 and 8 deals with movable property. Then how can you answer A only? The most appropriate is going to be C, that is property. This is, these are like the most silliest mistake you can ever commit in your exams. I hope everyone got this, right? So property is the correct answer. Next one. When it comes to section 34, there is a term that has been used which is entitled. That term entitled means okay. See, I hope each one of you knows what is section 34. That is declaratory decree, right? So suppose I am not the owner of a property. Okay. So let's take an example of Taj Mahal. Right now, for this date, on 11th of November, Sandeep Khatri is not the owner of Taj Mahal. But I got a letter from the government of India that after 1 month, you are going to be the owner. So which means after 1 month, the ownership is going to be of me only. And on this date, if I go into the court of law and say, I have a right which may arise in future, you please do declare that. Is that possible? Can you apply section 34 there? The answer is simple. No, no, no. Why not? Because it deals with a present existing entitlement only. It has nothing to do with the right which may arise in the future. If the right will arise in the future, how can you get the declaratory decree today? Right? So the answer is A only. Nawab, first one to answer correctly, followed by Ladli and Mohit. Correct answer. Done? I hope you will remember the example as well for the rest of your life. Next one. Temporary injunctions are such as are to continue until. C is the correct answer. Nawab, Ayush, and Kanika, and everyone's answer is correct. Easy one, I don't think it requires any. Which of the following section gives specific relief? The key word here. Which of the following section gives specific relief? Kanika, Ayush, and Ladli, top 3 students to answer correctly. Done. Kanchan and Mohit, you have answered D. Can you please tell me your logic? Mohit, Kanchan, and Millie, why you have answered D or C? See, students, first please do understand the question. Which section gives you specific relief? Specific relief means, see, so suppose if, let's take an example of section number 6. What is section number 6? If someone dispossessed me from my own home, now I will not be settled in, I'm not going to be interested in any kind of a settlement that I will get any kind of amount or cash for my house. No, I need my specific relief. I need my house back. So that is all about section number 6. Okay. Section number 5 is the general one. Okay. No, Millie, section number 5 is not talking about specific relief. There is nothing which is, section 5 is just clarifying. Okay, section 5 is just clarifying that when you are going to file a suit for the recovery of immovable property, you may use CPC, that is section number 9, and so on. Okay, but that has nothing to do with specific relief. Section 6 is specific relief. I want my property, the same property, immovable property, back. Okay, and this is, I think, one of the most repeated questions, by the way. Okay, so that's it from my end, students. I'll continue from here in the next class. So anything now which you are not clear with, you may ask. So this is the link of my profile. Please make sure you follow that to get all the updates about my special classes and my plus courses. This is the link of my Telegram channel and my code Khatri10. And students, just 2 days to go. On November 13th at 11 a.m., you are going to have All India Judiciary Scholarship Test. So you can win 100% scholarship for your Unacademy subscription. And it's all, there's also a chance to win exciting prizes. And this is completely free, so I hope you have already enrolled yourself till now. And if not, make sure do that as soon as possible. Now, anything, if it is not clear to you, you may ask. You all are welcome. You're welcome, Kanika, Ayush, Ladli, Shivagori, and Mohit. Done? Chaliye ji. On that note, thank you very much. See you in my next class. Till then, yes, it's time to say peace.